America, land of the free, home of the brave, a nation built on the principles of justice and democracy, and apparently a place where you can be a convicted felon and still be president. This paradox has left many scratching their heads. That's the situation we find ourselves in after Donald Trump, convicted on 34 felony counts in May 2024, managed to navigate the legal and political landscape. Despite his conviction, he managed to win back the White House in November 2028, a feat that has never been seen before in American history. It's unprecedented, it's messy, and frankly, it's giving legal scholars nationwide a collective aneurysm. The legal community is in turmoil, debating the implications of this event. The crux of the issue? Whether Trump's election victory renders his prior conviction null and void, or if the legal system will uphold the rule of law. Can a democratic election override a legal conviction? This question is at the heart of the current debate. Can the will of the people, as expressed through the ballot box, effectively function as a get-out-of-jail-free card? This unprecedented scenario is testing the very fabric of our legal and political systems. Buckle up, folks, because this is going to be a bumpy ride. The nation watches closely as this legal and political roller coaster unfolds. Manhattan District Attorney Alvin Bragg isn't backing down. In the face of immense pressure and public scrutiny, he remains resolute. He's standing firm, arguing that a jury of Trump's peers found him guilty after a thorough and fair trial. And that verdict should stick, regardless of any subsequent electoral victories. The rule of law must prevail, no matter the political landscape. His team argues that President-elect immunity is about as real as a unicorn riding a dragon. It's a myth, a fantasy with no legal standing. Bragg's team proposes two options: delay sentencing until after Trump's presidential term ends in 2029, ensuring justice is served eventually, or treat the case as if Trump had, well, met his maker. This would mean immediate enforcement of the sentence. Both options maintain the jury's verdict and the legal weight of the indictment. The integrity of the judicial process remains intact. Essentially, Bragg's message is clear. In the eyes of the law, a president is a citizen first, bound by the same rules and regulations as any other individual. And no one, not even the leader of the free world, is above the law. This principle is fundamental to the very fabric of our democracy. Trump's legal team, unsurprisingly, has a different take on the matter. They are steadfast in their belief that the jury's decision should not stand in the way of his political career. They argue that his election victory effectively supersedes the jury's decision, suggesting that the will of the people should be the ultimate verdict. Their reasoning? The American people knew about the conviction when they voted, and they chose him anyway. This, they claim, is a clear indication that the public has already rendered its judgment. It's a bold claim, one that rests on the idea that an election is a de facto pardon for past transgressions. This perspective challenges traditional notions of justice and accountability. Adding fuel to the fire, Trump's lawyers are drawing parallels to President Biden's pardon of his son, Hunter Biden. They argue that if a president can pardon his own son, then the electorate's choice should similarly absolve Trump. They're claiming a double standard, arguing that it's unconstitutional for a president-elect, but not a president's son, to face the consequences of a pre-election guilty verdict. This argument raises questions about fairness and the application of justice. It's a comparison that's sure to ignite further debate and divide public opinion even further. The implications of this argument could have far-reaching consequences for how we view the intersection of law and politics. Legal experts are caught in a whirlwind of This situation is unprecedented, and the Constitution, surprisingly, doesn't offer a handy what to do when a convicted felon wins the presidency clause. The consensus seems to be that presidential immunity, while potent, isn't a magic shield that deflects all legal arrows. The Supreme Court has ruled that a president isn't immune to prosecution for actions taken before assuming office. This leaves Trump in a legal gray area, facing the very real possibility of serving as president with a criminal record. It's a scenario that could have profound implications for the future of the presidency. This isn't just a legal battle, it's a full-blown constitutional crisis. Trump's situation throws into sharp relief the delicate balance between the will of the people, the rule of law, and the very foundation of American democracy. If Trump's conviction stands, it sets a powerful precedent for holding even the most powerful individuals accountable for their actions. If it's overturned, It risks undermining public trust in the justice system and creates a dangerous precedent for future leaders. The outcome of this case will reverberate for generations, shaping not just the future of the presidency, but the very soul of American democracy. If you enjoyed this video, please go ahead and smash that like button, leave a comment below, and most importantly, subscribe to our channel for more exciting content.